Another issue we need to consider when we look at damages is the topic of remoteness. So what does that mean? Well, remoteness relates to how foreseeable the damages are. The famous case of Hadley Baxendale is really the leading landmark case on this. So what happened in that case was that Hadley was a miller, and he used some turbines to run the mills, and the turbines had parts, and one of these parts was a crankshaft, which is a big kind of heavy pole type object. Now, Hadley's crankshaft was broken, so he had to send it to get it repaired, and Baxendale, they were the suppliers of the transport services, so they were going to transport the crankshaft, and they were supposed to deliver it on a certain day. And they failed to do that, and they were late, and as a result, Hadley suffered losses because the mill wasn't operating as intended. Now, the question arose whether Hadley could claim for damages because of the delay. And the court basically distinguished between different types of losses. So, first of all, the court said there is liability for loss which is likely to flow from a breach. So, if by not delivering on time there was a likely loss that was foreseeable, then that's an ordinary loss and that is claimable as damages. There's also liability for loss when the consequences of the breach are known. That means sometimes it's not foreseeable, so you must make the other party aware of the circumstances. So for instance, Hadley should have told Baxendale it is particularly important that you must deliver on time because, and in this case, as was the case, because Hadley didn't have a spare crankshaft. So Baxendale expected there to be a spare crankshaft, so whether or not the delivery was late wouldn't really matter in terms of the mill being able to operate. But because there wasn't a spare, Hadley was not able to operate and lost a lot of profits. But Hadley never told Baxendale about this, so the court said that in this case, it was not foreseeable that losses would flow from the delay, so no ordinary loss. Now, in terms of extraordinary loss, that means loss which is not foreseeable, because Hadley never told Baxendale about the situation, about not having a spare crankshaft, that was not claimable either. So in the end, Hadley was not able to recover. Now this principle was applied in a case called Victoria Laundry and Newman Industries. This is another very famous case. What happened in this case was that the laundries had contracted, again, to receive a boiler from Newman Industries, and the boiler was used as part of their laundry. And the problem was that Newman Industries was very late in delivering the boiler. In fact, they were 5 months late. So, of course, that's a breach of contract because they didn't deliver on time. The question then arose, can damages be claimed? And if so, what sort of damages? Now, there was basically two types of damages here, because Victoria Laundry, they have their normal day-to-day operations, and the court said that in respect of those, any loss suffered by non-delivery or late delivery of the boiler, that's claimable because that's ordinary loss. So you don't need to specifically inform the other party ahead of time that you need the boiler in order to run your business. That goes without saying. However, Victoria Laundry had also gotten a very lucrative contract with the Ministries of Supplies, and the ministry contract was not able to be fulfilled because they didn't have the additional boiler and they didn't have the additional capacity. So that contract was lost, and that led to a big loss on the part of Victoria Laundry. However, in applying Hadley Baxendale, Victoria Laundry was not able to recover because for such an extraordinary loss, they should have informed the other company, Newman Industries, that they really needed the boiler on time. So the lesson we learned from this is ordinary losses are recoverable. However, if there are special circumstances, such as not having a spare crankshaft or having a new agreement, a new contract which is out of the ordinary, which is over and above the ordinary business, in this case that Victoria Laundry engaged in, or the ordinary income that they would generate every day. So if there's something extraordinary, if there's something on top of the usual business, then you need to inform the other party of those circumstances and let them know that delivery on time, or whatever the clause in the contract is of utmost importance, because if you don't deliver on time, if you don't get the product, the boilers, the crankshaft, whatever is on time, then you will lose that extraordinary opportunity and you will suffer the extraordinary loss. Now lastly, under the heading of remedies at common law, we also have to look at a term which is called liquidated damages. What's that? Well, very simply, liquidated damages means that the parties have, before their contract was agreed, talked about and thought about what sort of damages might be payable in case there were certain types of breaches. So a clause might say A promises to do such and such, and if A does not do it, or does not do it on time, or does not do it in the right way, then liquidated damages of so and so much are payable. So in other words, the parties have predetermined the amount of damages payable. So that's fairly simple, fairly straightforward. There are some quirks there. For instance, in the case of Dunlop pneumatic tire and new garage motor, which by the way we shouldn't confuse with the other Dunlop case, which we came across when we talked about privity. That was Dunlop pneumatic and Selfridge. Both of these cases are cases about sales below an agreed sum, so where there's a minimum resale price. However, in Dunlop pneumatic, the issue was a different one. So Dunlop had determined by way of contract with New Garage that their tires were only supposed to be sold at a certain level and not below that level. And for each tire that New Garage sold below that level, a penalty was payable. Now the question was whether that was actually a penalty or whether that was liquidated damages. And in the end, the court held that it was liquidated damages. What's the difference? Why does that difference matter? It matters because penalties are usually not enforceable without reference to the circumstances and to the actual losses, and you sort of have to go through the whole process. Whereas liquidated damages have one main advantage, which is you don't have to prove the loss, you don't have to prove the damage. Because it's liquidated damages, the courts will accept that the parties have agreed that, and so immediately upon a breach, irrespective of how much the loss was that was suffered, the innocent party is entitled to claim for the liquidated damages. So that's the advantage, but the courts will always have a look at whether the liquidated damages were just a sort of random amount. So for instance, when we talk about penalties, the amounts are usually very high amounts, which usually bear no resemblance to the actual damage or loss suffered. Whereas with liquidated damages, the parties must have really made an effort to try and assess roughly what the loss would be and how much the damages might amount to. So as long as the parties have made that effort to try and suss out a reasonable number, the courts will then enforce that number against the guilty party, and the innocent party is able to claim the liquidated damages without having to prove how much loss they actually suffered. And so, just to be clear, where there's a penalty clause, the courts will still inquire into how much the actual loss was and so on, and they won't just automatically enforce it, whereas with liquidated damages, they will. Let's move on then to remedies in equity. Now, the one you'll all be familiar with, because that's the one we kind of hear the most about, is specific performance. Specific performance means nothing else but a judicial decree ordering a party to perform an obligation. So, if you've agreed something by way of contract and then you refuse to do it, specific performance can compel you to do it. However, as we will see, usually specific performance will not be used to compel a person to perform a specific act. So we'll see that later on when we talk about injunction, but it will be used to compel someone, for instance, if someone sold a painting and the seller now doesn't want to hand over the painting after the price is paid. Well, you could say you can sue for damages, but if it's a lovely painting and the buyer only wants that painting, and after all they did have a contract to receive that painting, then the court may use, instead of damages, specific performance to compel the seller to hand over that painting. So that, in a nutshell, is specific performance. Sometimes the courts, however, will not order specific performance, even though it may seem to be appropriate. The reason why they wouldn't do that is because we always have to remember these are remedies in equity, and equity is all about fairness, so the courts will consider the overall picture, and Patel and Ali is a good case to demonstrate that. What happened in that case was that Mrs. Patel sold her house to Ali, and she was healthy, everything was fine, but before the house was handed over, so before the whole transaction was complete, Mrs. Patel contracted cancer and she lost her leg as a result. That made her immobile and she didn't want to move house anymore. Now, Ali wanted to enforce his contract for the purchase of the house by way of specific performance. So again, you can compensate Mr. Ali by way of damages. That's possible, but then he doesn't get the house, he just gets money. But Mr. Ali wanted the house specifically. So the court considered the situation, and the court said that it would not be fair in the circumstances to compel specific performance against Mrs. Patel, whereby she would have to hand over the house. So it was not available in those circumstances. But generally, it is available, of course, given the fairness requirement, we have to consider that, but generally it is available. If you've contracted to hand something over, to sell something, then you can be compelled to do that by way of specific performance. Again, unless, of course, the damages can do the trick. If damages alone can put parties in a position they would have been in, then, of course, damages are the remedies which the courts will apply. However, sometimes it needs to be specific performance. I think the example of the painting, someone buying a painting, is a strong example of where specific performance is really mandated and where damages are really not good enough. Now, injunctions really are the other side of the coin of the specific performance coin. So what injunctions are, they are judicial decrees preventing a party from breaching a contract. So in the case of specific performance, the party is ordered to do something, and in terms of injunctions, a party is ordered not to do something. And a great case again to illustrate this is Lumley and Wagner. So Wagner had contracted to sing for Lumley and at a concert. But then Mrs. Wagner found that there was an opportunity to sing elsewhere at a higher price, so she went elsewhere, and that was, of course, in breach of the contract that she had with Lumley. Now, Lumley sued, and the court held that Mrs. Wagner could be prevented from performing elsewhere by way of injunction. So the injunction served to prevent Mrs. Wagner from taking up the concert, the singing performance elsewhere. But note, as I alluded to earlier, the court did not compel Mrs. Wagner to sing for Mr. Lumley as had previously been agreed. And that's generally because the courts, that would have been specific performance, but generally the courts will not award specific performance or order specific performance if it involves some action on the part of the guilty party where they have to go and do something. So sort of to physically compel Mrs. Wagner to sing, that's not what specific performance is supposed to do. So she can be prevented from singing elsewhere, but she can't actually be physically forced to sing for Mr. Lumley. So that's specific performance and injunction. A nice pair of cases to sort of compare the two against each other. Now, rescission is a remedy that we've talked about a lot. We talked about it in respect of mistake, in respect of misrepresentation. That word comes up again and again. So we know what that means. Rescission means putting parties in a position before the contract ever happened, as if the contract had never happened. So basically sort of rewinding the tape, rewinding the clock, and trying to put parties back into their original position, which is difficult to achieve at times, but nevertheless, that's the aim of rescission. And so rescission is an equitable remedy. Now, a couple of cases on this. So in Barclays Bank and O'Brien, what happened there was that it was a couple, Mr. and Mrs. O'Brien, and Mr. O'Brien was in charge of a company, and the company was in a bit of trouble, so he basically mortgaged his private home, the one he shared with Mrs. O'Brien, in order to raise their overdraft for the company from the bank. Now, Mrs. O'Brien had to sign off on this, otherwise it wouldn't have been possible because the home was owned by both Mr. and Mrs. O'Brien. And in the event, the house was then foreclosed because basically the repayments on the loan were not forthcoming on the side of Mr. O'Brien and his company. Mrs. O'Brien at that point said, "Hey, you can't do that. I didn't allow this to happen." And of course she had signed, but then she was able to show that she was actually unduly influenced in signing that piece of paper, which basically mortgaged her house. So that contract was voidable, and in the end it was rescinded on the basis of her being unduly influenced. So sometimes the rescission is available because of things like that. So generally the idea is to put parties in a position as if the contract had never happened. Now, that's usually not available where there's a breach of contract. So where we have a breach of a term, well, you may terminate, but termination means that the contract comes to an end at the point in time of termination. You don't go back in time. Or, of course, you can claim for damages when there's breach of contract. So rescission is available only in other types of circumstances. So, for instance, in Barclays Bank, in the case of, that was a case of undue influence. It's also available where there's misrepresentation, which, remember, is not a breach of the contract. Representations are things which are said along the side, by the way. They don't form terms of the contract. They're not part of the terms of the contract. So where there's misrepresentation, a contract may be voidable and allow for rescission, as well as mistake. And so we have a case which kind of covers both of those, which is Leaf and International Galleries. And of course, what happened in that case was whether there was a misrepresentation about the sale of a painting which was meant to be a constable, and this was discovered 5 years later by the buyer that in fact it wasn't a constable. Now the court also discussed the scenario from the point of view of mistake, in this case a common mistake as to the subject matter, and the court held that in any case, coming back, it was not a common mistake as to subject matter, so that was not a possibility of voiding the contract on that basis, but neither was it for misrepresentation, even though there might have been a misrepresentation. And the reason was lapse of time, because 5 years had passed, and so that remedy was no longer available. Now, under the heading of quasi-contractual remedies, so this is essentially our third heading, we had the remedies which were available at common law in equity, and this is the third heading, quasi-contractual remedies. Under this heading, we're only going to discuss one item, which is quantum meruit. And quantum meruit basically means something to the effect of what has been earned. So this situation arises, or this is used when there is a contract, but you cannot sue upon the contract because there was, for instance, no breach. And the question then arises whether anyone can claim anything at all. And so in quantum meruit you can, and what you can claim for in certain circumstances is you can get partial remuneration because of partial performance, but it sort of depends. So whether you can do that or not. So in Cutter and Powell, this was the case of the seaman who had contracted to go on a 10-week voyage, and he was going to be remunerated very handsomely, but the remuneration was higher than it would have been because the ship's owner wanted to make sure that there was no desertion. There was the seaman and everyone else did their whole course of duty for the whole 10 weeks and didn't sort of abandon or desert after 5 weeks or 6 weeks or 7 weeks. Now, unfortunately, in this case, in Cutter and Powell, the seaman passed away during the voyage after 7 weeks. And then the wife of the seaman wanted to claim for the performance which had been rendered. So there was partial performance, so she wanted to claim for partial remuneration. However, that was not available in her case. Now, essentially, these determinations are really made on the basis of the facts, but that contract was such that there was higher payment than usually would have been paid for that amount of time, specifically because the ship's owner wanted to make sure that the entire contract is served, all 10 weeks. So there was no partial payment available in that case. However, in Sumter & Hedges, this was the case about the builder who didn't finish finishing their contract to build a building because they ran out of money and they weren't able to complete. Now, the person who wanted the building built, they actually went about and finished it themselves with the help of someone else, using some of the parts and materials which had originally been supplied by the original contractor, the person who was not able to finish the job. And so there, the court held that the person who had supplied the materials, even though they were in breach, even though they never completed the contract, they didn't do what they promised, they were still entitled to get compensation for all the parts and materials that they had put into the building and which were later, of course, used to complete the building. So there was some payment, although not for the services rendered, only for the parts that were and materials that were put forward. So to summarize, our main remedy in contract law are damages, and that's a common law remedy. So that's mostly what we deal with. Sometimes we deal with equitable remedies, The ones we discussed are specific performance, injunction, and rescission. There's also quasi-contractual remedies. That is where you have to, or you try and seek a remedy outside of the contract. So based on the facts, the contract doesn't offer a remedy, but the law may be able to help you out. Generally, all of these remedies are not available if there's legislation that supersedes them, that trumps them. So legislation always trumps other remedies. Thank you very much for your interest.